Some of you may have missed this yesterday, but we covered the vehicular homicide trial of Tory McConahie, who went on a three-county high-speed chase, led authorities on a three-county high-speed chase before ultimately crashing into a couple who were at an intersection and taking their lives. It was a pretty interesting case. One of his defense arguments was that the cops were negligent in chasing him. They shouldn't have chased him at such reckless speeds. They should have blocked off intersections and multiple other things. He actually sued the city where the crash occurred, where those law enforcement officers were involved, as well as the county sheriff's department. But he was ultimately found guilty on quite a few charges, and this is his sentencing hearing.
And I'm going to ask you to speak up louder. We do not, our court reporter is way over here. So those microphones are not the best in the world. If you just pretend that you're like Taylor Swift at a concert and you've got your mouth right there on the microphone and speak loudly.
Or pretend you're yelling at me, whichever one you want to do, Ms. Mindy. So, where are you employed
With the state of Tennessee
and what department?
Corrections.
And what is your position with the Tennessee Department of Corrections?
I write pre-sentence reports.
All right. Did you have an occasion to do an investigative pre-sentence report on a Mr. Tory A. McConaughey?
Yes, I did.
And that was after Judge Wolf had ordered the same in this case?
Yes, sir.
Did you prepare that pre-sentence report?
Yes, I did.
Did you file the original with the court?
Yes.
Do you have a copy with you?
Yes, I did.
And just for the record, Ms. James, what do you do in a pre-sentence report?
With the criminal history, education, residential, family, basically everything from school on to the current charges.
To where he currently is whenever you meet with him. And you said you do have a copy.
I do.
All right. Did you look at, you said one of the things you look at is prior criminal history, is that correct?
Yes.
What prior criminal history did you find for Mr. McConaughey in this case?
Well, on 2/10/21, there was a theft of property, 12/12/20 driving on revoked, 11/29/19 driving on
James,
revoked.
let me stop you. Are these all convictions?
Yes, these are.
These are not just charges. These are actual convictions. All right, I'm gonna go back on the theft of property from 2/10/21. Where was that out of?
That was out of Carroll County.
Okay. And so when you go through each one, if you would just tell what county they're at, if you don't mind.
Okay, so the theft of property was out of Carroll County,
And what was his sentence on that?
4 years.
All right.
And then the driving on revoked was out of Carroll County, and he got 11/29. And then another driving on revoked out of Carroll County. I don't see a disposition on that one. Then there was a DUI 9/16/18 out of Medina.
Okay.
11/29 suspended after 10 days in DUI school. And also a casual exchange there with 11/29 consecutive to the DUI.
All right.
Then 11/14/15, Schedule 2 drugs, meth. And this, I don't know what he got on that. That
Okay.
was auto.
Where was that out of?
That was also out of Carroll County.
All right.
In 3/25/14, 2 traffic violations, failure to use a safety belt and violation of Tennessee financial responsibility law, both out of Carroll County. 2/28/14, Schedule 6 drugs, also out of Carroll County, and that was auto created too, so I don't know what time we got on that.
Okay.
And then another traffic offense, 3/11/13, out of Carroll County.
And those were the convictions that you were able to find?
Yes.
And what do you, just out of curiosity for the record, what do you use to find those convictions?
We use the NCIC,
Mhm.
and then a lot of that doesn't have dispositions, so we contact the courts and get the dispositions, and a lot of times if they're really old, they don't have dispositions, so we don't put those on here.
Also, I see, I'm looking at page 9 of your pre-sentence report, Ms. James. And under prior record, there's a couple at the top there. What are those? Are those convictions for something?
Okay, those are actually the violations that he got on the probations that he was on.
Okay.
So,
So what were those?
so in the 2014 case 63, that was out of Carroll County, he got 2 violations while on probation there.
Okay.
And then in CR 19, 2016, that was a Carroll County. He got 3 violations on that probation.
Okay. So in one of those cases that he was on probation for, he had 2 violation of probations or whatever his alternative sentence was.
Yes.
And the other one, he had 3 violations of his alternative sentence.
Yes.
Okay. You also, I noticed on page 11, and you kind of talk about it there, but you talk about the history of community supervision. Is that something you look at as well?
Yes, and that basically has the same information, his violations while on community supervision.
Okay. And that goes through the violations of their community supervision while they received alternative sentences.
Yes.
Okay. What, besides going through his NCIC and their criminal history and education and background and those types of things, what else do you do as part of your pre-sentence report?
We do something called a strong R, where it's basically the same information, but it scores them on their risk of reoffending and the needs that they may have to keep them from reoffending.
Okay. And you did a strong R in this case?
Yes, I did.
And what was the result of that strong R assessment in this case?
In his case, he scored high for reoffending on violent charges.
Okay. So that score and that test that you give gives you some type of mark that says whether they're at risk for reoffending, whether they're at risk for reoffending on a violent status or
On drugs or
mental health, drugs, et cetera. Is that correct?
Yeah.
And in this case, you found that, or the test found that there was a likelihood of reoffense by violent offense.
Yes.
And you submitted that or prepared that on November the 3rd of 2023. Is that correct?
Yes.
And you filed that with the court, as we mentioned earlier.
Yes, I did.
Your Honor, we would ask that that be marked State's Exhibit number 1.
Marked as Exhibit 1.
Yes, sir.
And that's all the questions I have, Mr. James.
Mr. Sanders, you have questions?
Yes, thank you, Your Honor. Good morning, Ms. James. I'll talk with you about a few things. First of all, regarding Mr. McConaughey's criminal history that you were able to find,
Yes.
as I heard you testify that I think that you found that there were 3 prior felony convictions on his criminal record. Is that correct?
Theft of property, Schedule 2 and Schedule 6.
So three total prior felonies. And the first one, what is the offense date on the first felony conviction that you found?
The NCIC gave a date of 2/10/21.
And what was the disposition date or the conviction date of that offense?
7/9/21.
And do you recall from your investigation what the offense date was for the current case that we're here on today?
February 10th, 21.
And that's those occurred on the same date, correct? The offense?
Well, the theft of property wouldn't have, well, I'm not sure. I guess it would have theft of property charge. That's the vehicle he was in. I didn't look to see what the theft property was, but
And do you know what level of felony conviction that was?
no,
Do you know what level of felony any of those felony convictions were?
no, it doesn't have a level of felony on the report.
I noticed in your report that you discussed with Mr. McConaughey personal things about his background as far as his drug abuse.
Yes,
What did you all talk about regarding that?
you have a page.
I believe it's the bottom of page 9.
Okay, so he had told me that he started using alcohol at the age of 12 and that he had used marijuana, meth, heroin, cocaine, Suboxone, and acid in his past. And he did admit that he was high on meth the day of the accident. And he completed Safe Harbor. And he said he was clean for several years until a breakup, and then he started using again just prior to getting more convictions.
Did you all continue at that time to also talk about mental health issues and different things that he had experienced?
Yes, we did.
And what did you all talk about, or what was reported to you?
But he had said that he was diagnosed with borderline personality disorder, anxiety, and depression in 2021. And he's on medication.
Did you all talk about what treatment, if any, he had received
Well,
due to those mental health issues?
now I'm pretty sure he had said that he hadn't really received any until he got to jail and he started receiving mental health.
Are you referring to the Humphreys County Jail?
Yes.
When he got here, he began treatment? Okay.
He said Centerstone comes to the jail.
And flipping your page there to 10, you mentioned there that he reported to you some further mental health breaks at the top of page 10.
Yes, back in 2013, he had attempted suicide by overdosing on Tylenol, and he was sent to Pathways in Jackson and admitted there. He didn't really say how long he stayed, but they put him on trileptal while he was there. And he said he hadn't had any suicide attempts since that time.
What's Mr. McConaughey's educational background? I jumped back a page, it's on page 9.
Oh, yeah, he graduated from Clarksburg High School in Carroll County in 2012, and then he continued his education and received a certification in tool and die January of 2013.
Did you discuss with him his employment history?
Yes, yes, we did.
And what was reported to you regarding his employment history?
He had worked at Black & Decker as a machinist, and then McKenzie Valve, Ameripride, Pacific Manufacturing. And he said that I think he was fired from Pacific Manufacturing and hadn't held a steady job since, but he kind of just been doing jobs here and there.
Does the 2019 date, did that correspond with what he reported to you as far as the addiction issues that he's suffered?
What do you mean?
Well, you mentioned that he told you about a relapse following a breakup.
Mm-hmm. Are you asking if he was having problems with employment after the breakup, when he started
Well,
using again?
I heard that you said that since being fired from Pacific Manufacturing, he has not held a steady job. And he reported that he lost that job in April of 2019.
Yeah, that's what he told me.
And my question was, because you earlier reported that he had remained clean until 2019, until he started using following the breakup.
Yes,
So those dates
yes.
correspond. Okay. I would like to talk to you about the risk and needs assessment briefly. I noticed that your report includes a recommendation.
Yes.
And what was that recommendation?
Well, alcohol and drug assessment and follow all recommendations, cognitive behavioral intervention, which is a mental health program, and then victim impact.
Now, you stated that the examination resulted in a high violence score with a high or moderate need in family residential alcohol drug use. Does that score that he received, is that due to the drug abuse and mental health issues?
I believe are you talking about the high for violent score?
Yeah, it says a high violence score.
I believe that's based off of his most recent offenses. I mean, I don't tally the scores done by the computer. I just put in the information that I have, and then it gives me a score.
Okay.
So that was what I was looking at, is probably the most recent criminal history is what it's basing that off of.
So an alcohol and drug assessment, by that I assume that you mean that he would be examined to determine the full extent of his issues with alcohol and
Yes.
drugs. And then he would be provided with some sort of recommendation for program or treatment.
Yes.
For that. What do you mean when you say a cognitive behavioral intervention program?
That works with people on their thinking, why they do the things they do, their behaviors.
Does that also get into the mental health issues?
A little, I think. I'm not sure, I've never taken the class, but cognitive behavioral, I know it deals with their thinking and their actions and how their thinking leads to actions and things like that.
That's all the questions that I have, Your Honor.
No further questions.
Thank you, ma'am. You may sit down. Morning, you may call your next witness.
Statement Thomas Jennifer Hooper.
You solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. So have a seat, please.
Good morning. Would you just state your name for the court?
My name is Jennifer Hooper.
Okay. And I think you prepared something you want to read today. Is that right? Mm-hmm. Before you read that, I just want to ask you a couple of questions. How were you related to Larry and Patricia Franklin?
They were my parents.
They were your parents. How many siblings do you have?
I have one,
And that is
Franklin,
your brother. Okay. How many grandchildren did your parents have?
5.
5.
Brand new one.
Do what?
I said they have a brand new one.
They have
It's really cheap.
6 now.
Yeah. Well, no, 5 together.
Gotcha.
With her,
I gotcha. Okay. I'm just going to let you read to the court what you've written, and this is about how this has affected you. Is that correct?
Correct.
All right. Go ahead, Mr.
On February 10th, 2021, my parents stopped by my house on the way home from Dixon. And an hour and a half later, after they left our house, our lives changed forever because of the actions that were taken that day. Not only did this accident devastate our family, but it absolutely rocked this community as well. They were loved by so many people. This has been the hardest 2.5 years trying to figure out how me and my kids can live life without them. My kids were super close with their grandparents. My son struggles now going hunting because that is what him and my dad did together since he was young. My daughter will be graduating college soon, and they will not get to see her graduate now. Even during basketball season, my mom and I would always text back and forth during the games during our favorite basketball team, the Duke Blue Devils. There have been so many times I have wanted to pick up my phone to text her about something great or terrible that they did. Then I realized I can't do that any longer. There will forever be a hole in our family's heart because of this. They had so much more life to live, so many more trips to take that they wanted to go on, and all of this has been taken away from us. I could sit here for hours and talk about how great they were. And now with the new baby that will be 2 next month, she's going to have to grow up without her grandparents now. She will not get to experience what my kids were able to experience with them.
And Ms. Hooper, how old were your parents?
67.
67, they were both the same age.
Mhm.
Anything else you want to tell the court? Judge, that's all we have.
Thank you, ma'am. You may step down. Do you have any other witnesses, Mr. Warnick?
That'll be the state's proof.
State has rested their proof. Mr. Sanders, do you wish to offer any proof at sentencing?
Let me have one moment, please.
No.
I would call Miss Lynette Beard.
Ms. Lynette Beard.
Do you solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Have a seat, please.
Would you please state your name for the court?
Lynette Beard.
And Miss Beard, what is your relationship or relation to Mr. Tory McConaughey?
This is my son.
And do you have other children?
Yes, I do.
And how many children do you have?
I have 3 boys.
And what are your sons' ages?
My oldest is 43. My middle son is 38. 36. I'm not sure. And Tori's 29.
Now, we've talked a little bit about why you're here today, and you understand what we're doing here today. Would you please talk to the court or tell the court about your son's educational background? As you brought him up.
Yes. We sent him to school. I worked hard with him to make sure he learned to read, and we lived on a farm. And
Where did he grow up?
well, he started growing up in Texas, and then we moved to Mississippi. And then when he was 10, we moved up here.
To Tennessee? Okay, where did you live in Tennessee?
Clarksburg.
Clarksburg. And is that's a community in Carroll County?
Yes.
Okay. Okay, sorry, I didn't mean to interrupt, but go ahead with what you were saying about his school.
We taught him a lot about farm life, animals. He loved the animals. He had chores. I mean, he wasn't just allowed to go do anything he wanted. He fed the animals. Sometimes you'd find him in the barn with the chickens sitting all over him. He just loved the animals. We had horses. He had a dog that he adored. He had problems in school. They weren't teaching him anything he was interested in until an English teacher got hold of him and inspired him, I guess.
Did he have behavioral problems in school?
No.
No issues there?
I think the only issue he ever had was his senior year. He decided to skip school, but he skipped school across the street from the school and was sitting in the window and got caught by the principal.
And
But that's the only,
did your son, did he graduate high school?
yes,
What high school was that?
Clarksburg.
And just, that was a standard normal diploma that he received?
Yeah.
After high school, did he continue
Yes, he went to
education?
a tech school.
And what kind of tech school, or what was it called?
Jackson Technical School, I think.
Okay.
Um,
And do you recall what his course of study
The
was?
machinist.
Okay.
School on that.
And following that, did he get jobs working in that field or
He
related
got a
field?
job working while he was going to school. It was kind of a training job. And then when he graduated, then he continued to work there.
And it's been testified to that he worked up until 2019 in that field. Is that accurate?
As far as I can remember, yeah.
During this time period, did your son did he have children with anyone? Okay, how many children does your son have?
He's got 4 of his, but he also claims his ex-wife's daughter. They were best friends, and when she had the baby, he just kind of became a father to her. So he still claims her today. So 5.
Until he was incarcerated or at any point prior, did you have an occasion to witness your son with those children?
Oh, yes.
And how would you describe those interactions with those children?
It just made you smile. He'd get out there and play with them. He'd get out on the floor with them. He'd buy them kits to put together, and we'd set up a table and they'd do it together. He'd get outside with them with the hose, and they'd just go at it. They adore him.
How old are his children?
His 2 oldest she'll be 10 this week, and then 9, and Edwards, I believe, is 6, and Natalie is 4.
She's the youngest.
She's the youngest.
At some point in Mr. McConaughey's life, did you notice and did he begin to have issues related to his mental health?
Yes.
What started that, or what did you notice, or what happened first?
When I realized it, or when I found out, I got a call at work that he had tried to commit suicide at school.
Was
And,
this while he was in high school?
well, he was 14, so yeah. in high
Okay.
school.
Okay.
What saved him was a friend of his found the suicide note in his locker. So I took him to the hospital, and then we took him to Cary Counseling to get him some counseling. And Tory's not one for talking about himself and how he feels. So the counseling sessions didn't work for him. They tried to get him into group therapy. But like I said, it's hard for him to talk to people about how he feels. So,
And during that time period or afterwards, was he diagnosed with any sort of mental health diagnosis?
depression at the time.
Was he given medications?
Yes, I want to say it was sertraline, but it made him sleepy. He couldn't
work because he just felt so drugged down. So I quit taking it. So
When did you first realize that Mr. McConaughey had a problem with other substances, illegal substances?
well, I guess I wasn't paying attention. I didn't find out that he had been drinking till he was 16. And my husband told me that he'd caught him with the alcohol. So about 16 is when,
Now, I forgot to ask you earlier, but you're married? Are you married to Tory's father?
no,
You're married to Tory's stepfather?
yes,
Where is his father?
in Texas.
Did those mental health issues that you talked about, starting at age 14, did they get better
No,
as Tory got older? Is that no?
no,
Okay. The court reporter's taking down the things that you say that you can't see in your head. Did they get worse?
yes.
How did they get worse?
On one occasion, he was so depressed and he beat his head against the wall on a 2x4. So 2x4, and knocked himself out and ended up with a concussion.
You recall how old he was at that time?
Well, he was married by that time, so he was probably 20 or so.
At that time, was treatment being received by him or medication?
He didn't want to do the counseling bit. It just wasn't, he told me it just wasn't for him. And I tried to convince him that if he tried to open up, that he might get some help. He might realize that it was easier to talk to a stranger. Because it was definitely hard for him to talk to me about that. And I think it's because he thought it would hurt me. If he
He
told
thought what would hurt you?
his depression, how he was feeling.
Is that something that is in your family?
Yes.
Okay. Prior to Mr. McConaughey being incarcerated on this case, were you all close?
Very.
What do you mean by that? How often were you seeing one another?
Well, he lived with me till a year after he got married. His my oldest granddaughter, I had her for a year and a half before they moved out. So I interacted with him a lot.
Okay.
Mostly just before he'd go to work, and then when he'd come home, I'd still be up and we'd sit and talk.
Were those,
But we were close.
how would you describe those times? Would you describe them as good, or were they difficult?
Sometimes they were good, and sometimes they were difficult.
What do you mean by that?
I can always tell when Tory would be spiraling down, And I tried to talk to him because I've dealt with that myself. And I've done the counseling that, and it helped me. I tried to convince him that he needed to try. I think a lot of Tory's depression comes from his relationship with his father. He just kind of, when he turned 18, he just kind of dropped him. And I think that hurt tremendously. But there wasn't anything I could do about that. I mean, that part of his life was out of my hands. I didn't have any control of whether he had a relationship with his father.
During these times with Mr. McConaughey, did he become violent toward other people?
No, it was always towards himself. The suicidal tendencies. He didn't want to live. On occasions when he would talk to me, when he was so desperate, he would tell me that he just didn't want to live, that his days were black and gloomy, and he just didn't want to be here. He thought it would be better if he was gone from this world. And that would be hard to hear. Someone you love so dearly.
I can have one moment, Your Honor.
No.
That's all the questions I have, Your Honor.
No question.
Thank you, ma'am. You may step down. Mr. Sanders, you may call your next witness.
Your Honor, my client has an allocution statement that he would like to read
All right.
or state.
He wants to come around. Have a seat. He does not have to be sworn on an allocution. An allocution is not a sworn testimony. It is basically a statement, which I'll allow the defendant to make.
What do you want, Your Honor?
Just have him take the stand. Come right up here. Have a seat there.
Essentially, I'd like to start off by saying that I take full responsibility for the event that took place on February 10th, 2021. For the longest time, I could not wrap my head around why this terrible situation has come in between our families. Nevertheless, it numbs my heart to think that my addiction has led. I can only imagine what you must think of me. That person. But since that day, I have not desired to be that individual anymore. So I try to look at it as they gave their life to save mine. As hard as that may be. Still to this day, I will never fully understand why God has given me so many chances to live. And with that, I give you my sincerest apologies. I know that all the stars in the world won't bring them back. But Lord knows if I could go back and take the place of it. have asked myself, my family, and God to forgive me for what I've done. But I can only pray that you forgive me as well. Thank you.
Anything further? Thank you, sir. You may stand down. Anything further, Mr. Sanders? And I'll hear you an argument. You have been rebuttal proof?
No, sir.
I'll hear you an argument.
Well, Your Honor, this is obviously a tragic case. Passing of Mr. and Miss Franklin is difficult, obviously, for their family. And as Your Honor knows, the jury has found Mr. McConaughey guilty of all counts. Just to kind of go through that, from my understanding, Your Honor, he was found guilty of 2 counts of vehicular homicide by intoxication, 2 counts of vehicular homicide by recklessness, an evading arrest, a DUI second, driving on revoked, a possession of drug paraphernalia, and 2 counts of reckless endangerment against the 2 city police officers. Of course, the vehicular homicides, Mr. Larry Franklin and Miss Pat Franklin. It's my understanding, based on the law, that count 1 and 2, the vehicular homicides by intoxication, would be the primary sentences to move forward. Counts 3, 4, and 6, which are the vehicular homicides by recklessness and the DUI, would merge. So my understanding would be that Your Honor will be dealing with counts 1 and 2, the vehicular homicides by intoxication, which are B felonies. Count 5, an evading arrest by motor vehicle, which is a D felony. Count 7, a driving on revoked, which is a misdemeanor. Count 8, possession of drug paraphernalia, which is a misdemeanor. And counts 9 and 10, reckless endangerment, which are E felonies. As Your Honor knows, but just for the record, the vehicular homicide, the B felony, carries a sentence of 8 to 30, depending on the range. So there's 2 counts of that. Counts 3 and 4 merging. I won't touch on those. The evading is a D felony. It carries 2 to 12, depending on the range. The driving DUI would merge. Driving on revoked and the possession of drug paraphernalia are both misdemeanors at 1129. The reckless endangerments are E felonies, and they would carry 1 to 6 years. The state filed, Your Honor, originally when this case took place, a notice of enhancement that was filed originally. Let me go back and look. On March the 8th of 2022, we filed an amended range of punishment and notice of impeachment on April the 20th, 2023. And I know Your Honor has that before the record. That amended notice of impeachment and range of punishment, I won't deal with the misdemeanors because those were, well, I'll take that back. I'll touch on them because I think they're relevant. But in docket number 14 CR 63, on March the 8th of 2016, Mr. McConaughey was found guilty in Carroll County Circuit Court with possession of Schedule 6 with intent to deliver. That was an E felony. On that same date, with a different offense date, docket number 16 CR 19, he was found guilty of theft of property of a misdemeanor. In that same docket number, with an offense date different than the theft of property, he was found guilty Possession of less than a half gram of methamphetamine with intent to deliver and sentenced to 3 years was a C felony. In docket number 16 CR 9 count 6, on the same date as the methamphetamine charge, he was found guilty of possession of drug paraphernalia. Then in docket number 21 CR 90, on July the 9th of 2021, he was found guilty of the offense of theft of property and sentenced to 4 years. The date of that offense was February the 10th of 2021. So I touch on those for the purposes of range, Your Honor, and as Your Honor knows well, but just so I have it on the record, of course, range 1 on those B felonies carries 8 to 12. Range 2 carries 8 to 20. The state believes that Mr. McConaughey is a range 2 offender on counts 1 and 2. That being on 3/21 of 16, Mr. McConaughey was found guilty of a C felony in, like I said, 16 CR 19 of that C felony. So that gives him 1 C felony. In docket number 21 CR 90, he was found guilty of C felony theft. Now, the date of that offense was 2/10/21. So I want the court to, or I just want to draw the attention to the courts that in section 4035-106 was where we deal with multiple offenders. In that subsection B4, it says, except for convictions for which the statutory elements include serious bodily injury, threatened serious bodily injury, or threatened bodily injury to the victim or victims, or convictions for the offense of aggravated burglary, convictions for multiple felonies committed within the same 24-hour period constitute 1 conviction for the purposes of determining prior convictions. And the subsection B of 4035-106 talks about a prior conviction, meaning conviction for an offense occurring prior to the commission of the offense for which the defendant is being sentenced. So Mr. McConaughey is being sentenced for an offense that took place on February the 10th, 2021. If we go down to that subsection, we're in that 24-hour period. The argument could be made that is 1 conviction, but I would say that under that subsection, can accept 4 convictions for which the statutory elements include serious bodily injury, threatened serious bodily injury, or threatened bodily injury to the victims or victims. I think that subsection takes out that 24-hour period, making things 1 conviction. I think the proof shows, Your Honor, that
you're relying on the fact that he was convicted of the theft of this truck before in July of 2021, but the theft occurred hours before the death of the victims. Correct. In this case.
It occurred on February the 10th, 2004, same date as this happened.
And I understand your argument. The problem with that argument, it seems to me, is that under State versus Blovett, 904 Southwest 2nd, 111, 1995 Tennessee Supreme Court, the Supreme Court dealt with that issue, and they said a prior conviction means a conviction that has been adjudicated prior to the commission of the most recent offense for which the sentence is to be imposed. Is that still current law, or is that something different?
I have not found anything different, Your Honor. I'm strictly going by the code section, and that case was prior, and I'm aware of that case. That case was prior to the changes in this code section. So I'm relying on the fact that prior conviction means a conviction for an offense occurring prior to the commission of the offense for which the defendant is being sentenced, and that's under 4035-106B. So that would be the state's argument, and like I said, then granted, normally that 24-hour period gives us for lack of a better word, Your Honor, having been in the defense side as Your Honor was at times, gives you a freebie. We've all been aware of that, but I think that there are exceptions to that, and I think those exceptions are in place here, and thus that conviction for that theft on 2/10/21 gives him that second prior felony. And as Your Honor knows, he would, on those B felonies, he would have to have 2 prior felonies in class or 2 down. So at the B, he'd have to have 2 to 4 within the B to the D. So the state would argue, Your Honor, that yes, that case, I don't know that, I have not found anything that says that case has been overturned. But I would argue, I think that this statute was modified after that, after 1995, and that with that definition of prior conviction in subsection B1, and with that exception in subsection B4 of 4035-106.
So your argument is that the language in subsection B under that statute that says, in determining the number of prior convictions the defendant has received, prior conviction, subsection A, prior conviction means a conviction for an offense occurring prior to the commission of the offense for which the defendant is being sentenced.
Yes, sir. And that theft occurred prior to the vehicular homicide. It occurred prior to the reckless endangerment.
Okay, that one got a little confusing for a second there, so I had to actually look this one up. So what they're talking about is the multiple offender statute in the Texas Code, which helps determine the length of time he can be sentenced based on prior convictions. And a prior conviction is defined in the statute as an offense that occurred prior to the commission of the offense at hand. So the prosecution is arguing, well, he stole the car before he went on this high-speed chase, so it occurred prior, so he was convicted of that in a separate county, so that should count towards making him a multiple offender. The judge is noting that there was a case in 1995 where someone went on a crime spree. He was adjudicated for all of the crimes at the same time, but the state in that case argued that the first part of the crime spree occurred before the second part, so that made him a multiple offender by the time he was sentenced for the second actions. And in that case, it was overturned, and they said that prior convictions are those which they have been adjudicated prior to the commission of the second offense. So he would have had to have been sentenced for the theft of the car before he went on his high-speed fleeing from police in order for this to count. However, the prosecution's arguing again that this case happened in 1995 and the statute has been revised since then, and that language wasn't added in. There was nothing done to modify the statute itself to clarify that. So if they had intended that, they would have modified it. Yeah. It's all about getting him more time.
As far as, and so, in Your Honor, we'll make that decision, but that the state believes that with that exception, there are 2 convictions that make him a multiple offender on the B felony vehicular homicides. When you go to count 5, which is the evading, he also has 2 E felony convictions, Your Honor, and we filed, of course, the amended range notice of impeachment, range of punishment. But he has the E felony for the Schedule 6 out of Carroll County, which the sentence was imposed on 3/8/2016. And then he has an E felony, and that is docket number 14 CR 63. Then he also has docket number 16 CR 19, which is an E felony for theft of property. Excuse me, that was reduced to misdemeanor, so I apologize, Your Honor. The methamphetamine conviction in 16 CR 19 is a C.
Well, if I buy your argument about the Class B felony convictions being range 2, then would he not be range 2 for all offenses?
Well, Your Honor, I'm not going to pretend to be smart enough in the sentencing matrix to understand, because as you know, that the sentencing matrix specifically talks about 2 down, and from a B that would only reach to to a D felony. Now that would reach down to the evading. That if Your Honor doesn't buy my argument that that's 2 convictions, then we have those 2 E felonies that I think would count. And then he's got 2 E felonies for reckless endangerment. He's got 2 prior E felonies, so they would be in class. So he would be in range 2 for those E felonies.
Well, and I know I've continued to interrupt you, but this is a
That's
rather
all right.
important part.
That's all right, Judge.
If you look at the comments from the committee that adopted this new statute that was adopted and modified after that Supreme Court decision,
Yes, sir.
those comments state the following. Subsection B sets forth the factors which must be considered in ascertaining the nature and type of prior felony convictions necessary to impose a range 2 sentence. Prior law restrict the time frame in which a defendant's conviction record could be considered for enhanced sentencing of a subsequent offense. The Commission believes that all prior felony convictions should be considered in determining eligibility for a multiple offender classification. Thus, subsection B2 permits consideration of all felony convictions occurring at any time during the defendant's life.
And I would agree with that, but those are comments. Those are not the code. And trying to explain multiple persistent offenders to people is difficult. I don't understand it most of the time, Judge, so it's difficult. But having said that, and agreeing that the comments do say that, we think that Mr. McConaughey is a multiple offender for all of these convictions. That would put him at range 2. And if my calculations are right, that puts him at 12 to 20 on each of the vehicular homicides, meaning the vehicular homicides by intoxication as everything else merges. Then on the evading, that would put him at 4 to 8, which is range 2. Of course, the driving on the DUI would merge as well. The driving on revoked and the paraphernalia are both 1129s. Then the 2 reckless endangerments would carry 2 to 4 as enhanced or multiple offender range 2 sentences, Your Honor. So if my calculations are right, and I went to law school, so I didn't have to do math, but having said that, if my calculations are right, Mr. McConaughey has if you find that he is a range 2 offender, would have a maximum possible punishment of 58 years. He would have a minimum punishment of 12 years if you found that he was a range 2 offender. I'm not going to try to pretend what the possible sentences are if you find that he's range 1 on some of these, on a partial amount of these sentences, and range 2 on other parts of these sentences, because it becomes wildly too much for me to try to figure out, to be honest, Your Honor. But we think that Mr. McConaughey is a range 2 offender on each of these, and the state believes, Your Honor. Now, and that's talking about his convictions that we gave notice on. We also have that within those ranges to get between 12 and 20 is prior criminal conduct, Your Honor. And Your Honor's heard that through Ms. James's pre-sentence report. You've also heard it through, or it's also a part of our record, because he did have a misdemeanor theft. He had a prior misdemeanor possession of drug paraphernalia, according to his record in the pre-sentence report. Let me get to that. I think that was page. There we go. He had a prior DUI, Your Honor. He had a prior driving on revoked, 2 prior driving on revoked out of Carroll County, then a casual exchange out of Medina, then failure to use a seatbelt, some other minor traffic offenses, Your Honor. So the state would argue that Mr. McConaughey not only besides the necessary offenses to put him within a range 2 or to be considered a multiple offender, he has enough prior criminal history, Your Honor, to move him up into those maximum ranges within range 2. We also filed on November 17th, Your Honor, a notice of enhancing factors. And one of those is just what I touched on, that the defendant has a previous history of criminal convictions or criminal behavior, in addition to those necessary to establish the appropriate range under 4035 114.1. I just touched on that. We also filed that the defendant possessed or employed a firearm or explosive device or other deadly weapon during the commission of the offense. That's under 4035 114.9, Your Honor. The Court of Criminal Appeals has held, specifically one case I have is a reported case, State versus Bobby Tate, 912 Southwest 2nd, 785, that the court has held that a motor vehicle can constitute a deadly weapon within the meaning of the definition set forth in subsection A5 of 3911-106-5, and that was an aggravated assault. But the Court of Appeals has held on multiple occasions that a car can be a deadly weapon. So the state would submit, Your Honor, that the car is a deadly weapon and he used a weapon during the commission of his offense. The state would also submit that under 4035 114.10, Your Honor, that Mr. McConaughey committed this offense when the risk to human life was high. Your Honor heard from Mr. McConaughey's own statement when Officer Taylor at the time testified and showed the video that Your Honor watched and was submitted into evidence, that Mr. McConaughey stated that he traveled from Benton County, or Carroll County actually, until the moment of impact. His own words were over 100 miles an hour and I never let off the gas. You saw the video, Your Honor, of Mr. McConaughey almost hitting the police cars as they tried to put out the spike strips. And so there was plainly no hesitation when the risk to human life was high. Paul Rice testified, Your Honor, that he saw in his rearview mirror of the car or truck coming towards him. His testimony was he thought it was going to hit him. And then when it went by him, it shook his truck. And then there was an explosion. There were, according to Officer Taylor, at least 4 vehicles in the intersection stopped at the red light, not counting the other cars and not including the Franklin's cars. So the risk to human life was very high. And Mr. McConaughey, through his own words, had no hesitation in doing this. So we submit, Your Honor, that enhancing factor is appropriate. Furthermore, Mr. McConaughey, based on his prior record, was on community corrections and probation, and those were violated as a result of this, and those were in the pre-sentence report. So he was on a release at the time that he committed this offense, Your Honor. So we believe that enhancing factor is applicable.
So you're saying he was on probation at the time of this offense? And that's based upon the prior conviction for which one of the convictions?
For the, let me get the right one, Your Honor. 2016 CR 19, which was, make sure I have the right one, Judge. A theft of property, a possession of methamphetamine, and possession of drug paraphernalia. And on page 9 of the pre-sentence report in 2016 CR 19, that he was violated 3 times on that. But the most recent one was his sentence was revoked to serve on 5/30/21, which was after the date of this wreck.
We had a pending violation.
He did, correct, Your Honor. He'd been violated and revoked to serve 120 days on November the 6th of 2018, on a partial revocation, was released, was again arrested and partially revoked to serve another 120 days on 6/1/20, and then had another revocation where he was revoked to serve that sentence on 5/30/21. So the state believes, Your Honor, that in the notice of enhancing factors, that all four that the state has submitted are applicable to Mr. McConaughey's sentence, and thus takes within that range, as we submit range 2, 12 to 20. And again, if my math is correct, that's a maximum of 58 years. And the state thinks, Your Honor, that, tragically, 2 people passed away here. On top of that, he evaded arrest at 100 miles an hour and then nearly hit 2 police officers while he was evading arrest. So the state would submit that, Your Honor, that the maximum sentence within the range is applicable in this case. So he's looking at 12 to 20. So I think 20 is an applicable sentence for the vehicular homicides. I think Your Honor could run those consecutively. The evading would be an 8-year sentence. I think it would be applicable to run that consecutive. And I think the reckless endangerments would be at a 4-year max. Those would be applicable to be run consecutive. And then the DUIs, the driving on revoked and the paraphernalia, Judge. So the state thinks that an applicable sentence would be 58 years. Those would be within the appropriate range as the state has submitted and would be an appropriate sentence based on the facts of this case.
Mr. Sanders?
This is certainly a most tragic case. As tragic a one as I've ever been involved with. Point out that Mr. McConaughey accepted full responsibility for his actions that day. You've heard that from him. Getting into the sentencing, the charts and the graphs that we go by, I respectfully disagree with General Hornick about what range my client is. I submit to the court that as far as the B felonies go, he is without question clearly a range 1 offender. And the reason that I say that is if we look at the statutes that we're talking about, the court's already pointed out the appropriate language. The statute clearly defines what the definition of a prior conviction. And a prior conviction for purposes of multiple offenders, and I'm quoting, prior conviction means a conviction for an offense occurring prior to the commission of the offense for which the defendant is being sentenced. And now if we go back to that definition and apply dates to it, it becomes very clear. Prior conviction means a conviction, in our case, July the 9th of 2021, for an offense that occurred prior to the commission, 2/10/21 in our case, of the offense for which the defendant is being sentenced. So when the acts that were committed in this case that gave rise to this case, he had not yet been convicted of that offense because that conviction occurred some 5 months later. So I submit that conviction does not count as far as a prior conviction for purposes of range of punishment. So if that one is taken away, then my client has only 2 prior felonies at that point, one being a C, one being an E. The statute states that priors must be higher than what we're looking at currently or 2 lower, which would mean it must be a C, or a D. We only have 1 C. So for purposes of enhancement, he has 1 prior felony conviction, which puts his range of punishment on those 2 B felonies not at 12 to 20 as the state has argued, but at 8 to 12 years. Counts 3 and 4, as stated, we agree that those would merge, as does the DUI. Looking back at the enhancement factors filed by the state, Mr. McConaughey has a previous criminal history. It speaks for itself. The court can determine the extensiveness of that or lack thereof, however the court sees fit. His record speaks for itself. Number 2, the defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense. I submit that factor does not apply. While I concede that in certain cases a automobile can be a deadly weapon,
You don't think an automobile traveling 100 miles an hour through an urban area constitutes a deadly weapon?
I think that it does, but I think in this particular case, for this specific purpose, it is an element of the offense. In order to be convicted of vehicular homicide, a person must be operating an automobile. And so for that reason, I submit that it's not an appropriate enhancement factor because it's an element, a specific element of the offense for which he was convicted. So if I'm correct on the B felonies, that his range of punishment is 8 to 12 years. Looking at the rest of the counts, the lesser felonies, I think that the court can determine range on separate offenses within the same conviction. So while he may not be a range 2 on all offenses, the court can still find him to be at a different range for those lesser offenses because it's undisputed that he has a prior C and a prior E. So the court can sentence within that range. Your Honor, the court heard from my client's mother and from the pre-sentence report as far as my client's mental health and the issues that he's experienced in his life. Tragically, that resulted in the loss of 2 lives. And it's nothing that we can undo here. But this court, Mr. General Hornick has outlined a number of years that would be in excess of what the statutes would permit a court to do if someone committed a premeditated murder, which is the highest crime that we have on our books, the A felony being 51 years. And we certainly don't think it would be appropriate in this case to give an excess of what a defendant would get for the premeditated killing of another individual. So we would ask the court to take all of this into account when imposing its sentence in this case, Your Honor.
Judge, if I could, just the deadly weapon issue, the case that I cited, State versus Tate, 912 Southwest 2nd, 785, is actually.
Go slower.
I'm sorry.
Southwest 2nd.
912 Southwest 2nd, 785. That is an actual aggravated assault case. And as Your Honor knows, and my reading of that case, if I read it correctly, and Lord knows I've read them wrong before, Judge, but in this case, I don't think I did. This was a case where the aggravated assault was by use of a deadly weapon. It was not by serious bodily injury. And the court said a motor vehicle can constitute a deadly weapon. And it cited some other cases as well. But, so I would submit, Your Honor, that even though it is vehicular homicide, that it can still be used as a deadly weapon and can be used as an enhancing factor. As for Mr. Sanders' argument that what I argued was for more than someone would get for one count of premeditated first-degree murder, he is absolutely correct. I am asking for more than that. And I have seen people sentenced for crimes that are not homicides to more than people get for first-degree murder.
I think it's a misnomer. Number one, when you sentence someone for first-degree premeditated murder, they get a sentence of life in prison.
Correct.
51 years is their release eligibility.
Correct.
It doesn't mean they're going to get out of prison. It doesn't mean that's the sentence. It just means they can't be considered for parole until they have served 51 years. So
Absolutely.
I think that's a misstatement of the law.
But we sentence people all the time who commit multiple crimes of heinous natures to more than they might get for first-degree murder. And we would submit it applicable in this case.
Well, this is a serious case and it has complex factors as a result of that. Because of this issue regarding the classification of the range, I'm going to take a short recess, hopefully a short recess, to be able to look more closely at the statute. Obviously, it is my intention to sentence the defendant to what I think the law provides and what I think the offense for which he is being found guilty justifies. But I think by the same token, I need to make sure that what sentence I impose is one that I think that the appellate courts will uphold rather than put this family through a second sentencing hearing in view of the tragedy that's already befallen them. So we'll take hopefully a short recess, and I'll try to get you an answer and come back and we'll finish this in just a little bit.
All rise.
Under the circumstances, then, what we have today is a situation where, unfortunately, I have to now make the decision to sentence Mr. McConaughey for the crimes that the jury of his peers have found him guilty of. So, in applying the sentencing considerations of the state of Tennessee, I'm required to consider all of the following. Under 4035 through 103 of the Tennessee Code, the sentencing considerations are set out. To implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. It's not the longest history of criminal conduct, but certainly Mr. McConaughey has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense. Our confinement is particularly suited to provide an effective deterrence to others likely to commit similar offenses. And clearly, confinement, not granting confinement would, in my opinion, severely depreciate the seriousness of this offense. Measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant, and that clearly applies in this case. He has been on probation. He's had felony convictions where he was placed on probation, and he has not been successful in those probations. The sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to the purposes of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. I find that very interesting that our legislature puts that language in there after saying that you should confine someone to avoid depreciating the seriousness of the offense, but then they tell you that that should be the least severe measure necessary to achieve that. Potential or lack of potential for rehabilitation or treatment of a defendant should be considered in determining a sentence alternative. In this case, there will not be an alternative. Trial judges are encouraged to use alternatives to incarceration that include requirements of reparation, victim compensation, community service. And then it goes on to talk about community-based alternatives. In this case, the court, following those guidelines that have been set forth by our state legislature, I'm required to determine whether this person, what range this person that I'm sentencing is. A standard offender is a person who is not considered to be a multiple offender, a persistent offender, and so forth. So in other words, a standard offender is someone who is by default someone who doesn't qualify for one of the enhanced provisions. A multiple offender, which is what the state contends the defendant should be, is defined as a defendant who has received a minimum of 2, but not more than 4 prior felony convictions within the conviction class, a higher class, or within the next 2 lower felony classes where applicable, or where a class A prior felony conviction if the defendant's conviction offense is a class A or B. He goes on to say, and this is where we've gone back and forth about this with both Mr. Hornick and Mr. Sanders. Subsection B of that statute, and this is 4035-106, subsection B says, in determining the number of prior convictions the defendant has received, 1, prior conviction means a conviction for an offense occurring prior to the commission of the offense for which the defendant is being sentenced. And then 2, all prior felony convictions, including those occurring prior to November 1 of 1989, are included. So you can read that and say, okay, prior conviction means an offense occurring prior to the commission of this offense. So the theft of the truck for which he has been found guilty and sentenced occurred on the same day of the vehicular homicide, earlier in the day, February the 10th of 2021. So that is a prior offense. It's an offense occurring prior to the commission of the offense. So his conviction, his conviction occurred in July of 2021, prior to the conviction in this case, but the conviction did not occur prior to the commission of this offense. So it leads to some ambiguity. And I took the break because I wanted to look at the case law that I could find on this. And under these circumstances, I would refer the parties to State of Tennessee versus Corby, Al Martin Blovett, and Dennis James Ogle. It's a Supreme Court decision issued in 1995. And so that we're clear, the comments that I had referred to on the statute that seem to indicate that maybe this could be considered as a prior, and for the record, if I didn't come back, it's without dispute that he had 1 prior felony conviction that's a Class C, and therefore it would qualify under this sentencing guideline. But the other one that the state is relying on is a Class B felony, a Class C felony of theft of the vehicle, and that was committed on the same day, but was convicted in July of 2021. And those were the enhancement provisions that the state provided for the notice of range of punishment to be increased. So the question becomes, can you consider a conviction that occurred prior to the sentencing hearing, and his conviction in this case in the sentencing hearing today, but was occurred on the same day, albeit prior to the offense for which he is found guilty here? So looking at that situation, I would point out that the comments that I relied upon were from the Sentencing Commission. And there's a lower note that says the Sentencing Commission terminated on June 30th of 1995. Sentencing Commission comments have been retained but do not reflect 1995 or subsequent legislation. So by that comment, it says that those comments that I read from on the Sentencing Commission occurred prior to this decision by the July 10th, 1995 Tennessee Supreme Court decision that I'm referring to. In that case, the defendants were found guilty pleas of a number of offenses. And what happened was all of the pertinent charges resulted from a crime spree which lasted approximately 1 month. All of the convictions, however, were adjudicated contemporaneously. The trial judge used the first guilty plea conviction to elevate the defendant's status to multiple, and then persistent, and then to career offender in each of the subsequent guilty plea convictions, all without reference to any conviction other than those which had been reduced to judgment in the same proceeding. Court of Criminal Appeals held that the prior convictions used to enhance a defendant's status beyond that of a standard offender had to have been reduced to judgment before the commission of the offense which supported the enhancement. So the pivotal question before the court was what was a prior conviction and was referred to in the above mentioned sentencing provisions. The Supreme Court agreed with the Court of Criminal Appeals and their conclusion, and that the term conviction for a prior offense as set forth in Tennessee Code annotated 4035-106 subsection B1 described an offense, the conviction for which had been reduced to judgment in an earlier proceeding. So that decision still seems to leave the door open to say that perhaps because in this case it was the same day that he had committed the prior offense, but he was sentenced for it prior to being found guilty of this offense. So it leads you to wonder, perhaps that would work. What it says here that the Supreme Court, in construing that, basically goes on to talk about the fact that notice must be given on an enhancement of the prior conviction, and therefore, if you're giving notice of the prior conviction, it can't be notice for something that a person hadn't been convicted of. The Supreme Court says succinctly in the following: we are sufficiently convinced, as we have stated, that a, quote, conviction for a prior offense, end quote, describes an offense, the conviction for which has been reduced to judgment in an earlier proceeding. And it goes on to say that, and it goes on to quote the Sentencing Commission's, the prior felony convictions used to trigger the multiple offender status must have occurred prior to the commission of the offense for which the defendant is being sentenced. So I think it's still ambiguous, and I hope that the state will appeal if they disagree with my ruling. So I'm faced with the prospect of finding him as a range 2 offender on a very questionable conviction situation where he is being found to have been convicted of something prior to being convicted of this, but it was on the same day. The commission of that offense was commissioned before that. Anyway, I don't think that it's clear from the law, nor do I think it's clear even from the Supreme Court's decisions. So I'm going to classify this defendant as a standard offender, and I do that because it is my opinion that that decision seems to indicate that you cannot use a conviction that occurs out of the same offense without having prior been adjudicated. This was an offense that was committed on the same day as the offense in this case. But under those circumstances, it is my opinion that erring on the side of caution, that I think it needs to be, he's found to be a range 1 offender. Now, considering then the sentences that are to be imposed, I look to the enhancement factors that the state has filed, and I had those a moment ago. Those enhancement factors are: 1, the defendant had a previous history of criminal convictions of criminal behavior, in addition to those necessary to establish an appropriate range. And I find that that is an applicable enhancement provision based upon the testimony in this case. 2, the defendant possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense. And this court finds that the case law is clear that an automobile can be considered to be a deadly weapon, and especially one in this particular situation that was used not only to commit the vehicular homicide, but prior to the vehicular homicide was an element that he used to commit the offense of reckless endangerment of the 2 officers on the side of the road. So clearly, this vehicle was used as a deadly weapon, and I believe that that does apply. Count 3, he committed the offense with no hesitation about committing a crime when the risk to human life is high. Clearly, that I cannot imagine a more callous disregard for the safety of other people than to drive through an area such as this at 100 miles an hour over 3 counties and without ever taking his foot off the gas. He just simply tried to evade law enforcement, thinking he could get away with it. So I find that to be applicable. At the time the felony was committed, one of the following classifications that he was released on bail or pretrial release, and I think the proof has established that he had been placed on probation, that probation had been revoked and extended, and there was an active warrant for his probation at that time. So I find that those 4 factors all apply. Looking then to the mitigating factors, there are no mitigating factors that this court finds were submitted or argued. The defendant's criminal conduct neither caused nor threatened serious bodily injury clearly does not apply. There's no indication he acted under strong provocation. There are no substantial grounds. I don't believe that the testimony has substantiated that substantial grounds exist tending to excuse or justify his criminal conduct. Clearly, he played a major role, not a minor role, in the commission of the offense. The number 6, the defendant, because of youth or old age, lacks substantial judgment. That doesn't apply. He's a middle-aged adult, or not middle-aged, but he's certainly old enough that he's not a child, nor is he an elderly person. There's no indication he was motivated by a desire to provide necessities. He was not suffering from a mental physical condition that reduced his culpability in this court's opinion. His use of methamphetamine, and there's evidence that he was on probation or had previously been convicted of the use of methamphetamine. So I have reviewed every other one of the sentencing mitigating factors, that none of which do I find to apply in this particular case. So the court makes the following ruling. Prior to pronouncing the sentence, I would just simply say the only person who bears responsibility for this is not his mother. It was not her fault that he turned out the way he did. Mr. McConaughey made the decision consciously to get behind the wheel of that truck while he was high on methamphetamine. You cannot draw any other conclusion other than when you see the video of him at the station that night. He made the decision to get behind the wheel of the truck. He made the decision to lead the police on a high-speed chase. All it would have taken was him to stop at any point when he was being pursued and surrender himself. But he instead made the decision, so he has to live with the consequences. As a result of that, the court finds that the factors involved in this case and the enhancing factors with the lack of mitigating factors justify the maximum sentence on count 1 of a Class B felony. He's sentenced to 12 years in the Tennessee Department of Corrections. Count 2, he is sentenced to 12 years in the Tennessee Department of Corrections on count B. And counts 3 and 4 are the vehicular homicide by reckless conduct, and those will merge with counts 1 and 2. Respectively, and count 5 is the evading arrest, if I recall correctly, and that one is a Class D felony. He's sentenced to the maximum of 4 years on that sentence.
Your Honor, I hate to interrupt you, but and I was going to ask earlier, I know you made your ruling as a range 1 offender. You didn't address range on the lower classes.
You know, and I thank you for correcting me because of that. That is a correction. I have intended to do that on the lower cases, and I should have done it on this one. Count 5 is a Class D felony, and it does qualify to sentence him on that offense as a range 2 offender, which would give him a sentence of 8 years. Is that correct, General?
4 to 8, yes.
4 to 8, and the sentence will be 8 years on that. Count 6 is the DUI charge, and it's merged with the vehicular homicide by intoxication, so there will be no additional sentence. Count 7 is a Class A misdemeanor driving on revoked license. He's sentenced to 11 months and 29 days in county jail to serve. Count 8 is a Class A misdemeanor drug paraphernalia. He's sentenced to 11 months and 29 days in county jail to serve. Count 9 is a Class E felony, which has a range 2 offender again, because while it gets confusing, Now that we're dealing with a Class D in count 5 or a Class E in counts 9 and 10, clearly his prior conviction that he has would meet the qualifications for classifying him on those offenses as a range 2 offender. So for that reason, he is sentenced on a Class E felony in count 9, which has a range of 2 to 4 years, if I recall correctly. And let me make sure of that.
That's correct, John.
All right. Then he's sentenced to 4 years on count 9 and 4 years on count 10. And that is an effective sentence that I have pronounced. Question then becomes whether to run those sentences consecutively or concurrently. Unless the court specifically classifies them as running consecutively, then it becomes automatic that they will be served concurrently. When I look to 4035-115, which is the Tennessee Code having to do with multiple convictions, the court finds that the court may order sentences to run consecutively if the court finds by a preponderance of the evidence that 1, the defendant's professional criminal doesn't apply. Number 2, the defendant is an offender for whose record of criminal activity is extensive. You could argue that that applies in this particular case. Skipping on down to what I think is actually applicable to count 6 or number 6 under that statute. The defendant is sentenced for an offense committed while on probation. The court finds that to be applicable. And the defendant is convicted of 2 or more offenses. Count number 10 under that statute. The defendant is convicted of 2 or more offenses involving more than one victim, irrespective of whether the multiple offenses were a part of a single criminal episode, and the court finds that separate consecutive sentences for each offense is in the interest of justice. I find that consecutive sentencing should be applied in this case simply because to do otherwise would simply mean that the deaths of Mr. and Ms. Franklin were not significant. And I think that they suffered a loss, the family suffered a loss, and that to justify that loss or to somewhat impose a sentence that is just in view of that loss, that requires the sentences to be consecutive sentences. And based upon that, it appears to me that we then have a consecutive sentencing total. And Mr. Let's see. 40 years and 2 11 months and 29 days to serve. And those are all consecutive to one another. Mr. McConaughey, I hope that every day that you are serving this sentence that I've imposed upon you, that you will remember the pain that you've caused on other individuals and what you've caused for your own family. And I hope that you will think about the choices you've made in life, because those choices are what brought you to this point. Anything further before I adjourn?
Your Honor, just for purposes of, we'll have to figure out times, but Mr. McConaughey, as Your Honor mentioned, was on probation and sentenced to revoke to serve on 2016 CR 19 out of Carroll County, and then the theft, which was the point of
these sentences will run consecutively to those sentences that he has already been imposed. He will begin serving this sentence after he has served the prior sentences.
And the credit, Your Honor, pretrial jail credits.
If he was serving probation violation or sentences not related to this case, then he doesn't get any pre-sentence jail credits. So
those jail credits would go towards that sentence.
In other words, he was convicted in July of 2021 and sentenced to 4 years. So that sentence is where he's been serving during this time. So he'll begin serving this sentence when that one is concluded.
So although he's been in jail here on these charges without bond, he would not get that credit?
No, because he's been sentenced in July of 2021. It's no different than anyone else who's serving a state prison sentence who's brought to this court to, answer a charge here. He doesn't get credit for that time served because that applies to a sentence from July of 2021 and not this one. But we are going to adjourn for lunch or recess for lunch, and at 1 o'clock we have the state versus
Danny Ragsdale.
Danny Ragsdale sentencing hearing at 1 o'clock.
Wonderful.
1:30.
1:30. 1:30.